In 2019, the tribunal ordered Ottawa to compensate children and families $40,000 each because the federal government willfully discriminated against them by underfunding the on-reserve child welfare system. The newly re-elected Liberal government says children should be compensated, but they have decided to once again challenge the way that it should be done. Crown Indigenous Minister Mark Miller and Indigenous Services Minister Patty Hajdu are holding a press conference just now, saying the appeal is a protective one which will give the parties more time to negotiate an agreement. Well, for more on this, we're joined now by Cindy Blackstock. Cindy, good as always to see you. The Justice Department waited until the last minute but decided to appeal the compensation order. How disappointed are you?
I'm really disappointed. You know, I've always felt like this case is about ending discrimination against kids and trying to make some reparations for the victims that were hurt. And it's now been going on for like 15 years. So it's disturbing to see that the federal government is not yet fully able to kind of put down its sword of litigation against First Nations children. But on the positive side, I'm hoping that we now have from the public pressure a moment where the federal government will really focus on ending the racial discrimination that kids and families are continuing to experience, so that we don't have any more victims in the future, that we finally have a generation that's treated fairly.
I got to say, I can't think of a time there was this much public awareness around a decision. The government says they still want to negotiate a deal and give children and their families fair compensation. What does that tell you?
Well, for me, there is no negotiation below these federal court orders, and I'll tell you why. It's because the federal court order is recognizing that the victims were the children and the families that were denied the fairness and services. It's not my money, it's not anybody else's money, it belongs to them, and it's for the harms that they suffered. So we don't ever find ourselves in a position where we would consent to either reducing that amount under any circumstances or agreeing that some people should be out when they're now eligible. That's not our decision to make. We don't have authority to make that decision, and we will therefore be defending those orders in every forum.
Cindy, as you mentioned, been nearly 15 years. Just for myself, that's almost half my own life. How much longer do you think families are going to have to wait for a resolution to be compensated?
You know, the good news is it's right in the Prime Minister's hands. So there's a tribunal order that says that once the litigation stops, within 10 days, there will be a meeting where we press the start button on the process to distribute the funds. That doesn't mean 10 days after the decision the checks will roll out, but we'll hire the company that will then do that work. And that will provide some comfort and certainty to families when that happens. So we just need the litigation to stop.
At the end of the day, Cindy, how much do you think $40,000 will go, or any amount for that matter, to making up for what these children and their families have been going through?
It'll never be enough. I mean, I just look at the residential school survivors, the 60 Scoop survivors, the day school scholars, and you know, you can never recover your childhood, and you can never recover those sacred moments with your family. But for some of these young people who have been formerly in care, we've heard, you know, this'll help me find an apartment in a safe neighborhood, the first safe, stable house I'd ever have in my life. Or I'll be able to reconnect with my community for the first time. Or I will be able to pay for my education or my trades program. And we've even heard from parents who have lost children who sadly were denied services under Jordan's principle. And some of those parents are thinking, well, we want to build a play park to honor our child, but so that other children have some of the help that my child never received. So these families and these children, they have plans to be able to make their own lives better and their other people's lives better. And that's why it's so important that the litigation stops and that the families and the victims finally get the compensation they deserve, plus other supports.
Now, Cindy, I understand that there is one order that the federal government won't be appealing. What can you tell us about that?
Right. So one of the orders that the government did appeal in federal court and lost was with regard to First Nations family or First Nations children off reserve who are recognized by their nations getting help under Jordan's Principle. The government was challenging an order that made that so. Thankfully, the federal court ruled against them and said, no, you've got to make sure that First Nations children, all First Nations children, whether they have status or not, who are recognized by their nation are helped under Jordan's Principle. So the federal court affirmed that, and the federal government has chosen not to appeal it, which means that First Nations children recognized by their nation, regardless of status off reserve, are now eligible for Jordan's Principle this year and next year, and you don't have to worry about your services being cut.
Some good news indeed. Well, Cindy, we'll have to leave it there, but appreciate it as always you taking some time for us.
Hey, thanks for having me. Take good care.